Welcome, everyone. My name is Cesar Rodriguez Garavito, and I'm the director of the Climate Litigation Accelerator here at NYU School of Law. CLX is a hub for research, advocacy, litigation, and collaborative strategizing on the role of law and courts in speeding up and scaling up climate action. In addition to doing research, academic research, and maintaining a database of rights-based climate cases, CLX curates a global community of practice that comes together every month in webinars like this one, and also runs strategic workshops on specific topics, regions, and cases with partner organizations around the world. We are in fact in the middle of a series of workshops with Brazilian organizations considering innovative approaches to climate action in Brazil, in the Amazon region. So we invite you all to the upcoming webinars. Again, we convene one webinar per month. And this term in the fall, in the Northern Fall this semester, we have a number of exciting webinars on issues ranging from litigation against big food companies for their climate impact to anti-climate authoritarianism in countries like India and Brazil, to the use of financial leverages to put pressure on states and corporations to do more against climate change. We will also be launching in a couple of months, definitely before the end of the year, a new CLX website with resources for the climate community and the climate action community, climate litigation community around the world, that will include in-depth case studies of landmark lawsuits designed in the form of story maps, storytelling case studies on landmark litigation cases like the one that we will be discussing today. So stay tuned for that as well. And it is difficult to overstate the importance of the decision that we will be discussing today. We call it the Shell case, but the official name is a lot longer, including, of course, the name of one of the organizations that led the effort, one of the plaintiffs, Milieu Defensive, and we have one of the members of Milieu Defensive with us today. So while previous lawsuits against governments have succeeded, including the Urgenda case also in the Netherlands, this is the first time that the Paris Agreement has been found to impose obligations on private entities, and the first time that a court has required a company to reduce its carbon emissions. Also, because of reasons that we'll discuss with our panelists today, because the ruling applies to Shell suppliers and covers the entirety of the Shell-related emissions along the supply chain, including potentially the consumers of the products that Shell produces. It is a far-reaching ruling that can have and is already having wide-ranging impacts, not only in the Netherlands, but around the world. And of course, and this is central to the mission of the community of practice and CLX's work, it is having a demonstration effect. It is inspiring other litigants and activists and researchers around the world that are actively considering or actually already pursuing litigation along the same lines against carbon majors and other types of corporations. And we really couldn't have a better mix of panelists for today's session, because in the spirit of CLX's work, they bring together research and advocacy, and we will make sure to take advantage of their expertise and their role in the case, either by actually being part of it or analyzing it and related litigation. And we'll start with Sjouke van Oosterhout, who's a policy officer in climate and energy at Milieu Defensive, which is one of the plaintiffs in the case. So Sjouke is also a climate policy expert whose work focuses on halting dangerous climate change. She previously served as Dutch youth representative to the EU for 2 years and stood as a candidate for GroenLinks in the 2019 European Parliament election. And then we have Dr. Laura Burgers, who's a faculty at the School of Law at the University of Amsterdam, where she's currently located. She just finished actually teaching a class today and had to run to this meeting. So thank you, Laura, for making the effort. She's currently an assistant professor at the Amsterdam Center for Transformative Private Law, a great name. She conducted her PhD on the democratic legitimacy of judicial lawmaking in European private law cases on climate change. And her postdoctoral research focuses on the rights of nature. She has followed the Shell case and other important climate change and human rights litigation closely. For those of you who are familiar with CLX's webinars, this will not be a series of presentations. This will not be a panel based on presentations. That has a place, but not in this community of practice, which is geared towards really kind of rapid fire exchanges and extracting what's most valuable for future research and advocacy and litigation. So we'll start by giving each of the members of the roundtable 5 minutes to comment on the key aspects of the case from their vantage points, and then I'll follow up with some prompts to hopefully foster exchange and dialogue among us all. We aim to end the roundtable part of the event around 35 minutes past the hour, and then we'll allow 10 minutes for questions from the audience. So everyone knows the drill by now after more than 18 months of this. So please, if you have a question, please post it in the Q&A section in the Zoom chat, and I'll try to bring this to the panel. And for those of you who are part of CLX's community of practice, who have registered for the community of practice, we will have a follow-up strategic discussion at a different link that you have received in your email. So we'll have to log off and log back on that second Zoom link after after 45 minutes past the hour. So with that, Shalke, I wanted to begin by asking you, please tell us about the basics of the case, what the legal basis were, what the claims were, what the court said. And if you could highlight the role of the standard of care in this unwritten standard of care in Dutch law, and also the role of human rights in the legal arguments put forward by your organization and other plaintiffs, that would be very helpful. Shalke?
Yeah. Of course. Thanks for that lovely introduction. Very happy to be here today. So I think maybe before I dive into the case, it's maybe important to say a line or two about why we decided to sue Shell, because Shell is actually, well, I think we all know it's a big polluter. It emits around 9 times as much as the whole of the Netherlands, accounts for around 3% of global emissions. And I think it was around 5 years ago that the team decided to do something about that. I think in recent months that we've had a lot of organizations come up to us and say, hey, we want to do a similar thing, but always good to keep in the back of your mind that there's a lot of research and legal work that goes into ending up where we are now with a verdict. So yeah, at the moment, around 80% of Shell investments still go to oil and gas, and also the money that they are promising to go to renewables, they're not really living up to. So still very dominantly a fossil fuel based organization. And basically what we were trying to do in the court case is rely on this unwritten norm, this duty of care that we have, which basically says that you're not allowed to cause serious harm to others if you can take reasonable measures to prevent that harm from occurring. And basically what that means is that we try to argue that Shell's contribution to the climate crisis is a violation of human rights, and that Shell has a responsibility to respect human rights. We therefore also strongly relied on the OECD guidelines, the UN guiding principles in that. And the court actually agreed with us on that and stated that companies, also in a general sense, have a responsibility to respect human rights, and that causing dangerous climate change is violating human rights and is violating the right to live and the right to family life. So that is quite groundbreaking, as you correctly stated before. I think maybe also one thing to highlight in this regard is that we often get asked the question, why are you tackling Shell? Shell is already doing so much to fight the climate crisis. They already have a climate ambition. Our aim in the court case was that we were asking Shell to reduce its emissions by 45% in absolute terms by 2030. And their current climate ambition is to reduce 20% by 2030, but in terms of intensity and also in an absolute sense. And what that means is they would still be able to increase their emissions by simply adding, for example, the amount of renewables that they produce. So yeah, that's also an important thing to take into mind. And what we've actually seen in the last years, of course, is something that we've been monitoring closely, is that since Shell announced its climate ambition for the first time, their emissions have actually still been growing. So yeah, I think quite right that we've decided to sue them. We've got our the verdict, which says net 45% by 2030, so a little bit different than our initial aim. And Shell actually has to start executing the verdict immediately, even though they have appealed. I think we can dive into maybe the different scopes a little bit later, or if you want me to do that now. It's quite
that for later. That will be the follow-up question, because that's a crucial one. So, but thanks for flagging it.
Yeah, but I think this is sort of like the basics of the verdict, what we're asking for. And I think one thing that's also worth mentioning is that, of course, we were doing this case with some 6 other NGOs as well as 17,000 co-plaintiffs. So people from all over the Netherlands have signed up to this. So yeah, really one of the things that we're trying to push is show that this is a case for and by people. Without them, we could have never done this case. But yeah, I think maybe that's enough for now.
Thank you, Sjoeke. That was a great introduction to the case. And Laura, from the point of view of your scholarship, your research, what would you say are the main contributions of this nascent jurisprudence? The case, of course, still ongoing, maybe may go on appeal. But at this point, what would you highlight in terms of legal and jurisprudential advances here?
Well, first of all, thank you so much for inviting me. It is really a great honor to be here. And I think like even an hour would perhaps not be enough to highlight all the important contributions that this case makes, because I think it is truly groundbreaking from all kinds of different angles. What I personally perhaps find one of the most interesting elements is Shell's initial reaction to this claim being brought. Because as you said, I did this research into the separation of powers in relationship to these climate cases, because that proves to be a very controversial point, I think also in a lot of American climate change litigation, where often this doctrine of political questions is invoked by the defendants. And the initial reaction of Shell was that climate is not something for courts to be dealt with, but rather something for the whole of society. And that is very interesting, well, for a number of reasons. Well, Shell sort of joined that narrative that this would indeed be something for politics rather than for courts. And I think, by the way, that that is getting less and less controversial in a way, that there is a legal development into legalization and even a constitutionalization of the climate. So we see the climate increasingly as an issue of human rights, which legitimizes judicial interference against public authorities. But this is interesting, of course, because Shell is a private authority or private company. So many of the constitutional lawyers in the Netherlands who were very much concerned with the Urgenda case against the Dutch government are not concerned at all by this case against a private party. So I think this legitimacy argument of Shell can actually be translated into a lack of legality argument, because they feel it's unfair that they have been operating in this highly regulated area of oil and gas, in accordance with all kinds of allowances. And still now all of a sudden they are confronted with a legal claim. And in turn, they also raise an effectiveness argument, because they claim that, and it has been said not only by Shell, but also by many others who have responded to the judgment in the public debate, that how can one case solve the climate problem? And there, I think it is extremely interesting what the court says, namely that indeed, as Sjoukje also already highlighted, all companies have this obligation to respect human rights. And thereby it also is implicated that all companies might have climate obligations. Now, I'm still working on a paper in which a colleague of mine, Tim Blaker, and I argue that this would not immediately result in enforceable legal claims against any kind of company or any individual, because there are still other thresholds that needs to be met, for instance, to have enough interest into a claim to get standing. But still, this is very interesting, and especially also in relationship to precisely something that we will be discussing further as well, as I understood, namely that there is this obligation of best efforts on part of Royal Dutch Shell to also reduce indeed its Scope 3 emissions. And why is that so crucial? Because, well, of course, I think all people here know the Carbon Majors report that says that about 100 companies in the world are responsible for 70% of global emissions. But that is, of course, including their Scope 3 emissions. So if you include those Scope 3 emissions, then actually litigation might become a rather effective tool, because we know that there are about 2,000 climate cases worldwide or something like that. But we would need only 100 to cover 70% of global emissions. So yeah, that I think that are two of the most interesting aspects of the case, but not, yeah, not, I would not
Just
say that that is only the interesting. Yeah. Thanks.
Yeah. And thank you for bringing in some of the objections and criticisms, because of course this is a highly contentious issue, and one in which, of course, lawyers for Shell and similarly located companies will continue to put forward those types of responses. So since you both have put the topic of Scope 3 emissions on the table, and not everyone is familiar with the term, and we shouldn't assume that even for specialists, and I'm definitely not one of them, this is not an easy term to deal with, but it is crucial both in this case and, as Laura said, in the effort to curb global warming. So let's start with Sjoukje. One of the really fascinating aspects of the court's ruling that was a reaction to a key argument put forward by the plaintiffs was that the UN guiding principles are to be used to understand the scope, the whole range of legal responsibility that needs to be taken into account when judging the impact of a given corporations, in this case, Shell's impact around the world on climate change. And this includes, and I won't use the language of scope 1, 2, 3 for now, I'll leave that to you, Sjoukje, who probably have mastered this language in preparing for the case, but I will put it in terms of the UNDPs, right? So that a corporation's legal responsibility includes suppliers and also the potentially consumers, right? Because the sphere of influence and the impact, the human rights impact of a corporation's activity cuts across the supply chain. And this is a very interesting and surprising development, because I've worked in the past in business and human rights, and there was a lot of skepticism, for example, as you surely know, about the potential of the UN guiding principles in fostering this type of hard law court decisions. And what you have managed to do in your litigation strategy is to turn a soft law instrument into hard law orders and duties, which is now a small feat. And I must note that John Ruggie, the author of the UN Guiding Principles, passed away just a couple of weeks ago, and he was an incredibly energetic scholar and interlocutor in these debates. There was a lot of debate about and there continues to be a lot of debate about the merit of the UN GPs, to the point that there's been this kind of divide in the field between the defenders and the critics of the UNDP. So if you could, Sjouke, elaborate on what scope 3 emissions mean, what this means in this particular case, and how you weaved into the strategy the framework of the UNGPs, that would be great.
Yeah, maybe first responding to the issue of the scope, because I think it's quite important also in understanding what the verdict entails. And so yeah, basically scope 1, the emissions that fall under scope 1 are the direct emissions of the Shell group. So think about the actual emissions when drilling, for example. The scope 2 emissions are about the suppliers. So for example, the electricity you need to run any of the Shell factories, for example. And then the scope 3 is the emissions from mainly end users. So for example, if you fill up your car at a Shell petrol station, the emissions from the products that Shell sells fall under scope 3. And when it comes to oil and gas companies, the scope 3 emissions tend to be the largest chunk of where their emissions are. So in Shell's case, it's around 95% of their overall emissions that fall under scope 3, under the end users. And indeed, it's true that it's been a traditional defense mechanism of oil and gas companies to say, okay, we cannot do anything about the emissions of our end users because we only can control our own direct emissions. I've heard our lawyer say once that the scope 3 emissions are actually the easiest ones to reduce, because you can decide as a company yourself which type of products you're selling. And if you're selling less emission intensive products, then of course your scope 3 emissions will go down immediately. Also, I think Laura also talked about this. If we were not able to include scope 3 emissions in court cases, or if we're not able to do anything about this, then suing fossil fuel companies might not make that much sense, because then we could only say something about around 15%, maybe 10% of their actual emissions. So it was very crucial that the scope 3 emissions were also included in this case. And what the court actually said is that for the scope 1 emissions, so for Shell's direct emissions, there is a result obligation. And then for the scope 2 and scope 3 emissions, so for the emissions from the suppliers and for the end users, there is a significant best efforts obligation. Now, of course, this sparked, I would say, wide discussion in the legal world as well as to what this means, a significant best efforts obligation. It was not elaborated on as much in the verdict itself, but the judge did give some examples of what a significant best efforts obligation could entail. It suggested that Shell could, for example, decrease its oil and gas production. So again, then sort of sell less fossil fuel products to make sure the scope 3 emissions would go down. One of the other things that the judge talked about, which was very interesting, was about lobbying. So Shell has been quite known for lobbying against ambitious climate laws in parliaments all over the world. So making sure its lobbying efforts would align with 1.5 worlds would also be something that could be seen as falling under the significant best efforts obligation. So I think that's quite important. And then coming back to the UNGPs, and as I said, also the OECD guidelines were very important in our court case. It was basically one of the 14 points that the judge used to fill in this unwritten duty of care. So it was one of the 14 points that was important to reach the conclusion that the court did. And I think one of the important elements there, and I think Laura talked about that as well, is that Shell is a very big player, and the influence that Shell has, often an influence that is, because its emissions are so large and is such a big player in the oil and gas industry, it has quite significant influence as well, that it really needs to exert that influence to fulfill the judgment.
We'll talk about enforcement in a moment, because there's a lot of course, interest in this, and the community of practice that CLX brings together is particularly keen to develop strategies that are as sophisticated on the legal drafting and the submission moment of the lawsuits as they are with regard to implementation. So that I'm glad that you also flagged that, Shauka. So Laura, do you want to elaborate on the point that you made earlier about the legal significance of the court and the case having tackled scope 3 emissions and along the lines that Shauka helpfully explained?
Yes, thanks a lot. But perhaps I also would like to make another point, and that is about this making soft law into hard law. I think you can say many things about that, but at least from the self-understanding, I believe, of the reasoning of the court, it's not doing that. So this is really a sort of indirect effect, an interpretive tool. So the court really looks at a private law obligation. And that I think is also significant in relation to that argument, or that sort of feeling of unfairness for Shell, that, hey, we have always been working with authorizations. Yeah, there was no legislation saying we needed to reduce earlier. So how come there's all of a sudden this court ruling? And that relates to this private legal principle that even when harmful conduct is not forbidden, a harm might need to be compensated, as it was also reiterated by a German court in the Yuya case there of the Peruvian farmer against the German energy company. So there is this duty in private law, in general tort law in the Netherlands, an unwritten duty of care, and the court uses all kinds of elements to interpret that. Indeed, 14, as Sjoukje said, and the UNGPs are one of them. But I think it is indeed extremely interesting to think further about what this means for other companies. And of course, climate change litigation has a dual effect. So on the one hand, it is it is confirming that legal obligations exist. So it is pushing a development in law. But of course, climate cases also have a second function, which is to communicate to the wider public, if you like. So immediately in the Dutch public debate, there was an enormous discussion amongst other companies as well. What should we do now? And in that regard, I think it's also quite significant that the Dutch part of Tata Steel now announced a few weeks ago to move to a more sustainable form of steel production. So other companies also feel that there is this legal obligation building. So I think that this to do something against climate change. And I think that is perhaps the most significant of this case, that it is pushing the development of that legal obligation.
Thank you, Laura. Thank you, Laura. And moving on to, I'm feeling that I'm following the leads of the panelists here, which is great. You've made my job very easy today. So I wanted to move to issues of implementation. One of the critical aspects of this lawsuit and other lawsuits that have succeeded at pushing governments and now corporations to speed up and scale up climate action is that they're very aware of temporality, right? And that they have shown to the courts that delays are costly, that climate change is not like any other, social and economic challenges. that it makes a huge difference whether or not humanity puts its act together now relative to 2 years, 3 years down the line. And that really, CLX is publishing a book out of Cambridge University Press that kind of calls for human rights advocates and scholars to factor in temporality more fully into the concepts and the strategies that are based on human rights to match kind of the nature of climate change. And that's being done by some courts, certainly by the German Constitutional Court in its May ruling on the Neubayer case. But this is also central to this ruling. So, Sjouke, to put it in more kind of mundane terms, what would happen if by 2030, if before 2030, if 2-3 years down the line, Shell continues to emit at the levels that it is currently emitting? And you mentioned that the emissions have increased. Is there any legal mechanism whereby you can go to the court before 2030, before waiting till the deadline is over, to put pressure on Shell to do what the court is asking it to do? Because as you said, the order is enforceable now, regardless of the fact that it is likely to go on appeal. And actually, also I wanted to ask you, do you think that Shell will appeal?
Shell has already appealed. Yeah, we're actually negotiating with Shell this week about upcoming dates for when the next court dates will be. So this is likely going to happen at some point. Well, next year, we're going to exchange. How do you say it in English, Laura? The documentations, the grieven, and then the year after, we'll probably see each other in court again. So they have already appealed, which of course does not free them from the obligation to really start executing the verdict. As you mentioned, time is of the essence when it comes to these sorts of, so we're looking into all sorts of ways to see what we can do up until 2030. One of the things that we have already been doing even before this court case is that, of course, we do some forecasting on what Shell's emissions will be. I think that will definitely help our case if we can forecast with some certainty that they're definitely not going to make it. And we're going to put public pressure, continue to put public pressure on Shell up until 2030 with that. So we're going to monitor very closely what they're doing. Friends of the Earth is a global organization, so of course that helps as well in keeping an eye on the new oil and gas developments that they start around the globe. So yeah, we'll publish an annual report, with the forecasting, with the new things that they're starting, keeping a close eye on their lobbying, etc. But when it comes to what we can do from a legal perspective, it might be tricky to go back to court before 2030. However, we're looking into other avenues. Perhaps we could do something against board members of Royal Dutch Shell, seeing if we can hold them accountable in a certain way. That would, of course, mean a different sort of procedure as well. But yeah, this is definitely something that we're still working on. But I think when it comes to this, public pressure will play a huge role as well if we have no legal avenues.
Thank you, Sjouke. I'm going to start weaving in some questions from the audience, and one of the questions has to do with private law and the role of private law in this ruling, Laura. And we know that you, of course, have looked into the connection between private law tools and climate action and litigation. And some scholars like Doug Kaiser at Yale have been making a powerful argument for years now that tort law need to be updated also to match the nature and the scale and the speed of climate change. And the Shell case has been heralded as a framed as a human rights case, but really has a core private law component, right? The core legal obligation comes out of an unwritten standard of care emerging from the Dutch Civil Code. So could you please comment on the role of private law in this case for those for audience members and community practice members who are interested in leveraging that set of tools for climate action?
Yes, thanks. Very, I think, good question. So this relates, I think, very much to a bit of technical concepts that you might also be teaching to your students, namely direct and indirect horizontal effect of human rights. It is very controversial whether human rights can apply in horizontal relationships, such as the one between, on the one hand, NGOs, and on the other, a private company like Shell. So what happened in this Shell case is not a direct horizontal effect of these human rights obligations, but rather an indirect horizontal effect, meaning that the court engages in what is also called consistent interpretation or harmonious interpretation of a national private, very open norm, in accordance with human rights law. And there it's of course very significant that the courts in the Netherlands already established in this earlier famous Urgenda case that indeed human rights can be violated if global warming exceeds 1.5 to 2 degrees Celsius because of all the consequences that will then occur. So I think that is how private law is used in this case. And what is interesting as well is that in the Urgenda case, in first instance, human rights were also used indirectly. But of course, that was a case dating from 2015, when I think that development, like the realization how much human rights can actually be impacted by climate change, had not yet crystallized that much. But in 2018, the Court of Appeal, and in 2019, the Supreme Court both went for a direct effect of human rights. And so the legal basis in the Urgenda case against the state was directly human rights in the end, according to the Court of Appeal and the Supreme Court. But I don't think that that will happen here in this case, because after all, Shell is a private company. So I suspect, well, my personal prediction would be that Shell will not win on appeal. And that the courts will do something similar with an indirect horizontal effect of human rights.
Which is a great segue into one of the questions from the audience about the impact of this case, because if Shell loses on appeal, because one of the arguments that are routinely made, not just by corporations, but also by governments, is what's been called the drug dealer's defense, right? If I don't do it, if I don't sell, if I don't produce oil, someone else will produce the same amount of oil, and the aggregate effect will be neutral in terms of carbon emission reductions. The court engaged with that argument very directly, and that was interesting to see. So the question from the audience is, do you foresee the possibility that if Shell loses on appeal, they might at some point begin to support similar regulatory requirements on their competitors in order to maintain a more or less even field? Meaning that if the regulatory pressure is in the direction of everyone reducing emissions as opposed to everyone behaving badly, that they, meaning Shell, might become a source of pressure for other players in the oil and gas business to also reduce emissions. Schalke?
I think it would be great to have Shell on our side in that regard. They're such a strong lobbying force, so that would be amazing. And as you said, the court was very direct in what it said about it, basically that every company has a responsibility, every government has a responsibility. Those responsibilities are separate from each other. So regardless of what the Dutch government is doing, Shell still has an obligation, and Dutch companies still have an obligation. So I think it would be very interesting to see what Shell will do if they're actually forced to do it, and that could be a possibility. That they would actually put pressure on others. Would be great.
Thank you, Sjoeke. We unfortunately need to start wrapping up. As one of you said, we could spend many more hours here speaking about the consequences, implications of this case. But before we wrap up, a final question for Laura, also coming from some questions from the audience. what's your view on the way in which the court interpreted the relevance and the implications of the Paris Agreement for private entities? Because that was also a major part of their argument. So could you, if you could comment on that, that would help us address a number of questions that have come up.
Yeah, thanks. I think that is a very important question because you see it coming up quite a lot also in the literature. So the way I see it is, but I mean, this is not perhaps like, I do think there is an amount of reasonable pluralism in this, how you can look at this. But the way I see it is that court uses the Paris Agreement actually more as a fact than as law. And what I mean by that is that the court resorts to the Paris Agreement to establish that there is an international political consensus that global warming should ideally stay well below 2 degrees Celsius. So I do not think that this judgment made the, like, I think the court even says it at some point that it does not intend to make an international agreement binding upon private parties. Rather, in relationship to all these other elements, it is one of the considerations the court uses to establish, oh yeah, there is actually an international consensus, that is the goal. And then we can also calculate what we should do on that goal. Oh, somebody is coming in, my apologies.
No worries, you were done with the answer. So, and I wanted to just follow up on it quickly before finishing here, to say that that's very much the role that not only the Paris Agreement, but the IPCC reports have had in previous litigation, which is not a small feat, because even if they're not interpreted as being binding on, say, in this case, a corporation, or as being hard law in some jurisdictions, courts have effectively used it across the board, and certainly in the human rights cases, almost 100 cases that we've studied in depth at CLX have used those two instruments as kind of the basis for an international consensus that, although it's not necessarily binding in the legal hard law sense of the word, can be used as an interpretive tool, or as offering kind of the best science and the consensus about the goals that then can be interpreted in terms of domestic law, which in turn can lead to binding obligations like the ones that the court in this case established in its ruling. So really the role of courts in many of these cases is served kind of as a conveyor belt from the international to the domestic, and in that way, courts are really helping fill an accountability gap, because the vague standards and the international scientific statements do not necessarily carry legal weight directly in every jurisdiction. So it's taking courts and litigants to put to bring that down to the level of implementation at the domestic level. So with that, unfortunately, we need to end. I wanted to thank Laura and Schauke again for being such great roundtable participants, and also invite everyone who's registered in CLX's community of practice to log off and log back on with the other Zoom link that we provided for the closed door strategic conversation. And for those of you who are interested in becoming part of CLX's community of practice, there's over 150 organizations already registered in that group. Please send an email to the address that we provided with the invitation to this public panel, and we'll be happy to look at your request. So thanks again, and great day, great evening to everyone, depending where you are.